So today we learn about drafting the concluding part of a deed of assignment. And the first clause we learn to draft is the testimonial. Now remember, in the operative part, in the main body, we saw the testator, which said, now this deed witnesses as follows. Now the testimonial says, in witness of which the parties have executed this deed in the manner below on the day and year first above written. So it's basically testifying about the execution of the deed, the signing of the deed by the parties. So that's the testimonial, in witness of which the parties have executed this deed in the manner below on the day and year first above written. And then the next clause that follows after that is the execution and attestation clause. So it would say signed, sealed, and delivered by the within named assignor. And then you now have the assignor's name stated, and he executes, he signs. And then for the attestation, you now have a witness who would attest to the signature. So you would say in the presence of, and then state the name, address, occupation, signature, and date of the witness. And then we now go on to also execute for the assignee. And it would say signed, sealed, and delivered by the within named assignee. The assignee would also sign, and then you would have the witness also attest to his signature. So it would say in the presence of, and you provide the name, address, occupation, signature, and date of the witness to the signature of the assignee. So that's how the execution and attestation clauses are drafted. Now, after that, what comes next is the franking. The franking is where the lawyer who drafted the deed would state his particulars, his name, his address, and so on. And so how it's drafted is by saying prepared by, and then we have the lawyer's name here, his law firm, his address, and his phone number. And finally, after franking, we now have governor's consent, because remember that based on the provisions of our Land Use Act, any disposition of legal interest in land must be done with the consent of the governor of the state. So, I mean, drafting the governor's consent, you simply would just say, I consent to the transaction contained in this deed. And then it's dated, it's signed by the governor or by one of his commissioners who will be acting on his behalf. All right, so that is how the draft is done. But I want to show you some other drafts, some other executions that are done by different parties. All right, so the first execution and attestation clause we saw was where you simply had two individuals who were involved in a transaction. Now, where you have a company involved in a transaction, all right, you would not be saying signed, sealed, and delivered by. Rather, this is how you're going to draft the execution when it's a company. You would say the common seal of, and then you'd state the company's name. Here we have Premium Bank PLC. So the common seal of Premium Bank PLC was affixed to this deed, and the deed was duly delivered in the presence of, and then you would have a director sign and another director of the company sign, or the company secretary sign. So they are the witnesses to the affixing of the common seal. All right, so that's how the execution and attestation clause would be drafted where it's a company that's executing. Now, another important execution I want you to be mindful of is where you have an execution being done by an illiterate. Now, you know that when an illiterate is involved in a transaction, by reason of the illiterate protection laws, you must have an illiterate jurat provided, otherwise the execution would not be valid. Okay, so when an illiterate is executing, a jurat would have to be included. Now, what would the jurat say? The jurat would simply say that the content of this deed was read and interpreted to the within named assignor or assignee, as the case may be, in so and so language, in this example in the Yoruba language, by me so and so of so and so address, and he or she seemed perfectly to have understood the same before affixing his sign or mark or thumbprint. And then for the attestation, it is attested to before a magistrate or judge or a notary public, as the case may be. So that's how it's done when you have an illiterate, all right? After the illiterate signed, so you would have signed, sealed, and delivered by the within named, and then you have the illiterate signed, and then the jurat would follow next after that. Now, the last execution I want to bring to your attention is when you have an attorney who is executing on behalf of a principal, all right? So you have a power of attorney that has been granted to an attorney to act on behalf of his principal. Now, when he's signing that deed on behalf of his principal, how is it going to be done? Now, you would say signed, sealed, and delivered by, and then we have the attorney sign it, and then you would have this statement follow after his signature. It would say lawful attorney for, this is the name of his principal. It says Chief Obi Kweme, the assignor, by virtue of a power of attorney dated and registered as in the Lands Registry, Mina, Niger State. So when you have an attorney who is executing on behalf of a principal, this is how it's done. So those are three executions that you must be familiar with when you have a company executing, when you have an illiterate executing, and when you have an attorney executing on behalf of his principal.